Regarding our item number 1, Lordship.
Yes.
For
Remember the state, Lordship.
for restoration, Lord. And
Yes.
recalling order dated
No, so you are not mentioning.
no, my lord.
Let him call the list.
Item number 1.
Yes. Give the rest.
For the petitioner, Lordship, I am
When it was dismissed.
Lord, 2nd December 2024, Lordship. The fact is, Lordship, the learned advocate on record is a patient of serious diabetic patient, Lord, and he could not accommodate on that very day.
The advocate.
Lord. And
Where have you said? Which paragraph?
my lord, paragraph 2 and 3 of the restoration application, Lordship.
It's a delay of 305 days, my lord, not 1 or 2 days, my lord. If could have been, my lord, 1 or 2 days or 1 month, I could have understood.
Could not
What is the issue?
Issue is, my lord, a issue settled
challenging the order of the
back to after 5 years.
Order of
challenging the order of the learned tribunal, my lord, regarding which has not been called.
tribunal. Obviously, what is the issue before the tribunal?
Lord, it was for the appointment
So let us.
averments which have
We
been
can
made.
consider the main also.
Yes, Lordship
Let
can.
you argue.
And most importantly, my lord, the order passed in 2019 and he challenged the
We'll
order
see.
in
We'll
2022.
see. Let him.
Fact is that at the pandemic situation, the petitioner could not.
Pandemic.
Sir, please place the case.
Lordship.
Yes.
এইটা আমার পিটিশনটা কোথায়? এটা এখানে অর্ডারটা আছে, আমার এখানে অর্ডার নেই।
So what is the infirmity in the tribunal's order? Tell us.
Tribunal in the tribunal order, my lord, kindly see. It is said, my lord, the second page, the last paragraph. My lord, I am reading out. In view of the submission made by behalf of the state, since we find the selection process for the post of Group D staff of 2,597 vacant post of Irrigation and Waterways Department was completed in 25th January 2008. My lord, this amendment is a totally false, frivolous, and
Let us
concocted.
see from your OA.
Because
So from your OA, what have you said in your OA? When it was complete?
there was a content application.
Come to your OA, sir.
Page number 14, inner page 3, paragraph 6 onward, Lordship.
This order, no one has challenged this order.
So what is your prayer? Come to your prayer at page 7 of the OA.
My humble submission is, my lord, I beg for a
Come to your prayer at page 7 of the OA.
Lord,
How such a direction can be passed?
Lord, my humble submission, Lord, the amendments which was made before the Honorable Tribunal is that selection process has already made in the year 2018. If, for the sake of argument, if I admit that selection process is completed, then why not? I'm putting the question to myself: why there is a contempt application before in 2013 before the Honorable Supreme Court, and Supreme Court has given direction within 2 months that has to be completed.
That you have stated in the OA that you came to know in 2013 that some order has been passed by the Supreme Court. Still, how this prayer can be granted? What is the right to such a relief? Show us. On what basis such relief can be granted to you that will give a direction that you should be called and you should be interviewed and given an appointment?
My humble submission is up to that, Lord. At least the opportunity should be given and consider my case, Lord. Not be more than that.
So you never applied earlier.
I have applied, my Lord, because there was.
Where is that averment? Show us in the OA. Don't make submission without pleading, please. You say that no advertisement was issued. Appointment was being made by making a requisition from the
In
employment.
arbitrary way, totally arbitrary way, Lord.
No, by making a requisition from the employment exchange. This is your averment in the OA. This is what your client has said, that it was being done from the employment exchange. You came to know in 2013 that some order has been passed by Supreme Court, and then you say that direct them to consider my case. How it can be?
Lord, at least they should not, for the sake of argument, if I take it that
Huh?
at least they should give me the opportunity, my Lord.
That's why we are saying how.
As and when there is a vacancy, Lord.
Who is going to stop you as and when vacancy arise? Who is stopping you?
Consider my case, because I am eligible candidate.
Who is stopping you? Who has stopped you that if vacancy will arise, you will not be considered?
My Lord.
Who has stopped you? Show us.
That, my Lord. Up to that, my Lord, will be done, my Lord. They should consider at least.
Third learned advocate for the
Item number 2.
Well, this is my written notes of submission. I was called for.
You have given the copy. Keep it on. Written notes of argument filed on behalf of the I am trying to hear the state before.
Item number 3.
In item number 3, I appear for the appellants, my lord. There are two applications on board, my lord, which is CAN 4 and CAN 5. My lord, both are for substitution of persons who were arrayed as parties but have, my lord, unfortunately demised. My lord, in CAN 5, my lords will remember the death certificate were not being supplied to us, so my lord had directed us to take steps in accordance with law and prefer an application in the absence of a death certificate. In CAN 4, my lord, there is a death certificate on record. May I, my lord, place those applications, my lord?
Respondent, where is the respondent?
My lord, they have been,
They were appearing on
they
the
were
last-
appearing.
Yes.
Simply, my lord, this will not cause any prejudice.
No, that's
And
right,
four.
but why in their absence? Where are they? Just ask them. We'll adjourn it not today.
My lord is adjourning it for the day.
Not today, yes.
Very well. I shall,
Just intimate them that
I shall verbally intimate them. Oblige.
Item number 4.
Let I appear for the respondent. This application. Let allow me to file affidavit in opposition. They have also filed reply. At least served on me. The opposition
which can are we taking? Can 5. Can 5. Scan 5. Application to go.
ভিতরটা খুঁজছি ঠিক আছে তাই
একটু লেখা আছে লেখা আছে
Yes. So application for recall.
my lord.
Yes. Yes.
My lord, this is an application for recall of an order. My lord, let me make my stand very clear.
Yes.
Let me make my stand very clear. It is not an application on any angst,
On?
on angst, on any being angry. But it is an application, my lord, keeping in mind that the dignity of the court, a court of records, in which, my lord, the Chief Justice is the master of the roster. even if there is an order made by the Chief Justice without any assignment, that cannot go on forever in a court which is a court of record. Therefore, the court would be, my lord, benign enough to recall the order it commends to, if it commends to the court that the order was not made in accordance with law. My lord, that is actually my humble approach before this honorable court.
Which order is passed by the Honorable Chief Justice?
My lord, this was an order.
2911 is by a different bench.
My lord,
2911-24.
no. 2nd of January 2024. Lordship kindly comes to the prayer of my application, which is assigned, that is Can 4. The prayer of my application, Can 4.
See, before us
Prayer
today is Can 5.
Not Can 5, Can 4. Can 4 is assigned to your Lordship.
Can 4.
Can 5 was assigned to the other bench. My lord, is Can 4.
Can 4, yes.
Can 4.
What is the date of the order?
My lord, the date of the order is 2nd of January 2024. Second of January 2024, the order was passed.
It is Can 4. See. This is Can.
In my application, it is page 35. That is the order, my lord. The last page of the last 3 pages of your lordship's brief. In which, my lord justice.
Just give us a minute. Okay. This is the affidavit in reply. This is the opposition. It's Can 4. Four. 2nd January.
Lordship, what the order? My lord, towards the end of this order, my lord, internal page 3 of the order, my lord Justice Bhattacharya was a party to it. Yes, my lord.
Just allow us to read the order.
So that is why it has been assigned.
Just allow us to read the order.
My lord, before your lordship proceeds to read, lordship, I will draw your lordship's attention to the heading MAT 2357. MAT 2357. What is MAT? MAT is, according to the determination that is to be made, the notifications your lordships have made, the book is there, my lord, because there is raining my books. I'll show to you. Mandamus appeal tender. Mandamus appeal tender. So MAT 2357 of 2023 and IA Can 1 of 2023. So it was an order made in a MAT. That is mandamus appeal tender. And who numbers it? Under the mandamus appeal tender, it was an appeal filed by my learned friend.
They are the appellants.
They were the appellants. They were the appellants against an order which they starts like this. Being aggrieved by and dissatisfied with the order dated 22/11/23 Mandamus appeal, memorandum of appeal, being aggrieved by and or dissatisfied with the order dated 22/11/2023, passed by the Honorable Justice Aniruddha Rai in CPAN. What is CPAN? According to your lordship determination, CPAN is contempt application, in contempt proceeding application. So it was a contempt proceeding in which an order was made on 22nd of 11/2023. They are filing an appeal. Is it against the entire contempt proceeding? No. On their own say, to the extent an interim order is passed. So an interim order passed in a contempt proceeding, it is that, not the contempt proceeding. Had it been against the entire contempt proceeding, it should have been a CPAN, but not MAT. I will come to that, my lord, how it goes. So an interim order was issued.
And you were the petitioner before the contempt court.
Yes. That order was made in a contempt proceeding, but it is limited to the interim order passed in that contempt proceeding. A mandamus appeal was rendered. So in that mandamus appeal, this order was made by the bench, my lord, presided over my lord, the Honorable the Chief Justice, sitting with my lord Justice Bhattacharya. This is the order. This intra-court appeal is directed against the order dated 22nd November 2023. Your lordship finds, by the said order, the learned single bench directed maintaining an order of a status quo. That is the interim order. On 25th September, over and in respect of the said land sites and the 5 numbers of web bridges to the extent of the issues and subject matter involved in the interlocutory application. Can 1, in so far as the subject tender process is concerned, which is also the subject matter of Can 1. We have heard the learned advocates of the parties. As could be seen from the impugned order, the learned single bench, after recording the nature of undertaking given by the learned advocate for the appellant before the learned single bench, while passing the order dated 25th September 2023 as recorded therein, the submissions made by Mr. Obrojit Mitra, learned senior counsel, appearing the alleged contemners, for the alleged contemners, as recorded above, would indicate that there was no violation of the undertaking given by the port authority before the coordinate bench. He also reiterates the same undertaking before this court as recorded above today also. Lordship will kindly mark this part of the order. There was an undertaking before a coordinate bench where there was an undertaking given, and in our respectful submissions, my lord, being the respondent, in our submission was that, well, the undertaking was broken. It was violated. So that is why we took out a contempt application. It was our contempt application.
Yes.
It was our contempt application which was in session before my Lord Justice Aniruddha Rai. So in that contempt application, my Lord, an interim order was made. Against that interim order, the appeal was preferred. In the appeal, my Lord, the Honorable the Chief Justice, sitting with my Lord Justice Bhattacharya, this order was made. After the above submissions were recorded, the learned single bench proceeded to take note of certain documents which were relied on by the respondent writ petitioners. The learned single bench also recorded that those documents are much prior to the interim order, dated 25th, which is an admitted fact as they are dated 3rd August. In such circumstances, we are of the prima facie view that the contempt application was not maintainable. prima facie view that the contempt application was not maintainable. My lord, my humble submission is, was the contempt application for adjudication in the bench? The mat before the judge, before the bench? It was not the contempt application. It was an application arising out of a contempt proceeding in which an interlocutory order has been made. That interlocutory order as to whether it is correct or not, for which a mat has been preferred, that was under consideration. Therefore, we entertain this appeal, and there will be an order of stay passed by the learned single bench, so and so. So, my lord, what I want to say, my lord, I want to carry before your lordships for your lordships' kind approval, subject to your lordships' approval, that while the bench was sitting to decide upon an interlocutory order made in a contempt proceeding, but taken an appeal, which is a mandamus appeal, not a contempt appeal. This, my lord, my respectful submission is before your lordship. Now, why am I aggrieved by this order, by the bench? Well, it is not any angus before the bench. My lord, now I will take your lordships to kindly go to page 9 of my application. A few paragraphs of my grievances
9.
I have ventilated. Yes, page 9 of my application. That one. Page 9 of my application. I will take your lordship with your lordship's kind permission, my lord. I will take you to certain paragraphs in
Yes.
which I have ventilated my grievance against this order. The said mat number 2357 of 2023. That was a mat of the port. We were the respondent. Together with Ken was listed under item number 15 as application in the daily cause list of their Lordship the Honorable Justice Devang Bose and His Lordship the Honorable Justice Shabbar Rushdie of appellate side on 11/12/2023. Their Lordships were, however, pleased not to hear the application and release the matter from the list, although the daily cause list show their Lordships had the determination to hear writ appeals, including the applications connected thereto on 11/20/23. Your Lordship will kindly go through. Kindly see, I have annexed the daily cause list of their Lordship the Honorable Justice Boshak and the Honorable Justice Shabbar Rushdie at page 22 of my application. Page 22 of my application. Lordship sees in page 22. Hearing of writ appeals. Your Lordship finds, my lord?
Yes.
Hearing of writ appeals, including applications connected thereto, irrespective of classifications and year. A mandamus appeal is a writ appeal. A mandamus appeal is made from the writ application. So, hearing of writ appeals, including applications connected thereto, irrespective of science. Where was it listed? Lordship kindly goes to page 24 of my application. Yes. Lordship got it, my lord, at page 24, Mat 2357 of 2023, with Can 1 of 2023. My lord, these were the all listed, but his lordship, their lordships were not pleased to hear it. My lord, their lordship were pleased to release the matter. Why? On what ground it was released? My lord, I have not, but in the affidavit in opposition of my learned friend in this matter before your lordship, they have included that order in the affidavit in opposition.
मैम कम करो, आवाज नहीं आ
In the affidavit in opposition at page 65 of my learned friend, it is included their lordships records. Their lordship recorded on 11/12/2023.
Yes.
Your lordship got it, madam. MAT 2357 along with I, CAN 1 is released due to lack of determination. My lord, I am not the judge. It is unto your lordships to decide as to whether on that day the bench comprising of Justice Bosak and Sabbar Rushdie had the determination. Yet then the matter was released. But my learned friend opposite my lord has come out with a particular stand, which according to my submission, subject to your lordship, a totally lame one. I will show to that. In course of time, I will show as to what is their defense for this release. I am not the judge. I am not the judgment. I have come before this court for justice. And justice for me and justice for them also. But justice for the cause. Justice according to the procedure. Justice for which the master of the roster has deputed you. He is the master of the roster. That is the judicial decorum. Because I am a judge, I cannot do anything. I don't say the judges do whatever they like. Sometimes they. Lordship will kindly pardon me. In my case, my lord, it has happened that my first submission is, although there was a determination before Justice Rashidi and before Justice Bashak, but it was released. So when it was released, where should it go? The procedure, as we all know, my lord, it will be placed before the learned the Chief Justice. Now, when it was placed before the learned the Chief Justice, I am asking a question to myself. When a matter is released by a particular bench, whether having determination or without having determination, it is the learned the Chief Justice, not being the master of the roster, has to take a decision as to whether it would be assigned to anybody else, even before the bench presided over by the learned Chief Justice. There must be an order of assignment. Since it has been released, my respectful submission is, my lord, to the possible extent I have, my lord, checked up the record, there was no such determination. After the matter was released by the bench, according to my submission, having the proper determination, yet then the Chief Justice, my lord, did not make any determination that this matter will be taken up by the bench presided over by the learned Chief Justice sitting with my lord Mr. Justice Dr. Taj. My lord, with deep respect to the bench, to the decency, the decorum, the rules and regulations, and my lord, the paterfamilias of the entire judicial system in the state, having, my lord, assigned as the master of the roster, not my term. It is the term used by the apex court of this country. Had to determine it. There was no determination. Yet then what happened? My lord the Chief Justice, my lord, then in paragraph 8 I say, at page 10 of my application, thereafter, MAT 2357 with Ken appeared under serial number 47. Marked for admission within bracket contempt appeal. Under contempt appeal in the appellate side daily cause list of their Lordship the Honorable Justice Sivagnam and His Lordship the Honorable Justice Bhattacharya, hearing appeals under section 19(1)(a) of the Contempt of Courts Act, amongst other matters, but not writ appeals and applications. Was it a contempt appeal? A contempt appeal is to be designated as CPAN. বইগুলো এসছে কোথায় বইগুলো এসছে ওগুলো রেখে দিই দেখে না দেখি The contempt appeal is to be designated, is to be determined, is to be named, is to be christened as CPAN, not this one. You know. Okay. But what I submit before your lordship, is it my मेरा इरादा है ये मेरा अपना मर्जी में बोल रहा है नहीं it is this one. This is rules relating to computerized listing of cause list of appellate side, and in this, my lord, it has been very clearly stated CPAN is the contempt appeal, MAT is the mandamus appeal from the writ application. My lord, this is what it is. Therefore, when it appears before my lord, the Chief Justice and the Honorable Justice Bhattacharya appeals under section 19(a) of the Contempt of Courts Act, lordship kindly goes to annexure A3 of my application, which is the cause list of my lord Justice, my lord the Chief Justice, the Honorable the Chief Justice, and the Honorable my lord Justice Bhattacharya. This is at page 29.
Page 34 is the relevant page.
Page 32, yellow slide.
34.
Page 30,
34.
page 34. Page 34. Page 34. Yes. Well, the cause list is printed, not our behest. Lordship kindly says, for admission, contempt appeal. Is it a contempt appeal? MAT 2357. Is it a contempt appeal? First a question. I would beseech your lordships to kindly consider. Well, the courts are always benevolent. Well, in this honorable court, my lord, I was trying to hunt out that order. In this honorable court, it has happened. My lord Justice Anil Sen, a former judge of this honorable court, he used to sit in court number 24. Court number 24. And my lord Justice Shambhunath became the Chief Justice. My lord, an order was made by my lord Justice Shambhunath Ghosh, the father of the great Pinaki Ghosh. An order was made by Justice Ghosh. But it is long after 10 or 12 years, when Mr. Shokinath Mukherjee was arguing a case, it is just contrary to the judgment that was given by Justice Shambhunath Ghosh. My lord Justice Ghosh was convinced what Mr. Shokinath Mukherjee was said, and Justice Ghosh was, my lord, benevolent enough to say that on such and such time I have delivered a judgment that was wrong. I want to record it. He did. My lord, your lordship will kindly pardon me. Lordships will kindly pardon me. The court is always benevolent. Well, the court not only rectifies this side of the bench, the court on occasion rectifies its side. And I shall come, my lord. By number of decisions I have come ready with to place before your lordship. So this was for admission, contempt appeal. Who made this? I said, say, lordship will kindly pardon me, my lord, if I use the word kapla. Who made this? It is the court officer? It is the court? The council? This side of the lawyer? Or that side of the law? I do not know. But this is what it is. On record. And, my lord, what was the determination on that day of the bench comprising of my lord Justice, the Chief Justice? Lordship kindly goes to page 29. Page 29. Lordship sees appeal under section 19(1)(a) of the Contempt of Courts Act. It can appeal under section 19(1)(a). It was an appeal against a writ order, against an order made in a writ appeal. Had this learned judge, my lord, had this learned court a determination to hear the writ appeal, I would have no grounds. Was there any determination specially assigned to the bench to hear this particular matter, being a writ matter? If there was a special assignment to the bench itself, I would have been out of the court. It was not. It was not. So, my lord, in my respectful submission, my lord, to the possible contempt according to my, I should say, the limited knowledge of law, I couldn't find any justification of this order being passed by a bench having no determination, no assignment. It cannot remain in the record of this court even after 20 years. It cannot. May whatever come the result of this order, that is altogether a separate question, and your lordships are not sitting for adjudication of those issues. Well, it's the limited question for which I have come before your lordships, to give a verdict as to whether this order should remain in the record of this court. Good, bad, indifferent, the result that has ensued after this order was made. For my professional quarrel, I can take well, for professional quarrel, my lord, I can take various grounds, but it should come to your lordship. Again, I repeat, my lord, and your lordship will kindly pardon me. May whatever result has happened about this order, good, bad, indifferent, I am not for that. I am only for this particular order made by a particular bench having no determination by the master of the roster of this court, even if he is the Chief Justice. And when it is assigned before your lordship, my lord, your lordship will consider as to whether the bona fide of this order, whether it should remain in the books of the record of this court. That is my case. So, my lord, paragraph 9 I have said, just making my grievance. It is respectfully stated that notwithstanding releasing the matter for lack of determination of hearing writ appeal and applications connected therewith, their lordships were pleased to hear the matter and further make an order dated 2/1/2024. That is the order before your lordships for a judicial review as to whether this particular order should remain or not. Taking into consideration an application arising out of a MAT application limited to a particular order, whenever I remind myself my duty as an advocate pleading a particular case, it is always my duty to point out to the court, even if it goes against my interest. That is the dignity of the bar. And I am respectful that every member of this honorable court is certainly aware of their own dignity. Nobody is blamed by me. I don't want to blame it. Neither I am blaming the court. It happens. It has happened. Now, Manad, with regard to this particular order, to defend it, my learned friend has given an affidavit in opposition. One particular paragraph, my lord, I will draw your lordship's kind attention to. It is just in one particular. Lordship kindly takes up the affidavit in opposition. Lordship kindly takes the affidavit in opposition, my learned friend. My lord, one paragraph I want to draw your lordship's kind attention to. Yes. My lord, this is paragraph 6 of my learned friend's opposition. Paragraph 6 of my learned friend's opposition. But paragraph 6 of my learned opposition deals with my averments in paragraph 6 and 7 of my application. In paragraph 6, my lord, I have referred to about the stay of the order by Justice Aniruddha Rai, and in paragraph 7 is most important with regard to paragraph 6 of my learned opposition. The said MAT 2357. This is my paragraph.
You are reading from paragraph
My paragraph 7,
of your application.
my application.
Yes, you already placed that.
I played that.
Yes.
Now it is in response to my paragraph 7.
Yes.
My learned friend in paragraph 7, my lord says, I say, your lordship got it? In page 5.
Paragraph 6, not 7.
Paragraph 6.
Yes.
Page 5, towards the bottom. The third line, I say that the Honorable Division Bench comprising of Honorable Justice Devanshu Bosak and the Honorable Justice Shabbar Rashid.
One Mr. Aprojit Mitra is leading me. He is online. May I take lordship's leave for 2 minutes, madam? I'm grateful.
Shabbar Rashidi did not have the determination to hear appeal arising out of order passed in contempt application. I call upon my learned friend to show from these rules that there can be a determination as arising order as appeal arising out of order passed in contempt application. Neither me nor my learned friend, but it is the court framed these regulations, these rules. There is no such computerizing listing of cause list of appellate side. Should I invent from here? Has the bar that right?
So there is no such categorization according
No
to you.
categorization. There is no categorization. And having checked up, after having gone through the computerized regulations rule, my lord, I ventured to submit, my lord, before your lordship, subject to your lordship's approval. It is a lame excuse. It has no footing for any justification of whatever kind. So this is what it is. For release from Justice Devanshu Bosak, this is the stand. This is the stand. Now, what is your stand with regard to the bench passing the order which I have come for, a recalling order? Was it a contempt application? On your own mandamus appeal? On your own memorandum of appeal? Is that a contempt application? Did you make any application or an appeal from contempt? The contempt application was disposed of. The contempt application was totally disposed of by passing an order that you maintain the status quo order as because a coordinate bench has already made an order up to on your own undertaking, and the same undertaking you are giving before me. Therefore, the contempt application filed by an friend, filed by us, is disposed. Therefore, what remains? The order of a status quo. Passed in an order without redundancy. Passed in an order without assignment. I beseech your lordships to kindly consider as to whether this order should remain in the record of this case. Now my learned friend has come with a total 65 pages, 65 though, কতগুলো page? 65 pages of affidavit in opposition. They have come with it. Well, this order has become already infractions. Automatically, an order of a court automatically goes up, has automatically becomes infructuous. A question I'm asking to myself. Well, your lordships are aware of this fact. It is a tried law that even if a receiver has been appointed in a particular case, the suit is disposed of, but no order with regard to the recall of the receiver continues until and unless the order is recalled. Until and until the order is recalled. It is an order, a judicial order. The judicial order cannot die itself. A judicial order is to be recalled by another judicial order or by the higher court. I beseech your lordship to kindly consider it. There has been, my lord, the order that was made in the original writ application. My learned friend also has taken a stand here in this in the affidavit in opposition, that the original application in which the status quo order, that has become infructuous. An original order, I mean the writ application, without any adjudication has become infructuous. Because I say, getting an order of its own as infructuous, well, even that is to be done, even if it is so, is an order to be made by a bench by a competent bench. But if I am approved, then I will. But if I am not, naturally I don't have a case. Still now that original application, original writ petition on which the status quo order was made, it has not yet been adjudicated.
It has not?
Not yet been adjudicated. From that number of writ applications thereafter, from that status quo, even it went up to the Supreme Court. My learned friend say that, well, you have taken a special leave petition against an order made by another bench over an order which follows from the original writ application. There, Supreme Court has dismissed your special leave petition, therefore, the original writ application goes. Is that the law? It is a dicta by a Mughal administration or a judicial administration set up by the constitutional law. The limit of the extent of the jurisdiction of a court, well, it has to be decided whether it is not. All this at all. But my lord, even if my learned friend, he has a right to bring it to your lordship's notice that this is what has happened. To that, my simple answer is, all those questions have not been specially assigned before this bench to adjudicate. All those questions have not been. It is a very simple question as to whether the order made on 2nd of August, 2nd of November 2024 would remain in the books of record as has been made without any special assignment or without any determination. My lord, that is the simple case that has been specially assigned to. So, my lord, I need not, my lord, exhaust much time on the questions as my learned friend has said. Now, to that, my lord, in my affidavit in reply, yes. Yes. To that, in the affidavit in reply, my lord, my learned competent junior, my lord, has dealt with all these particular allegations and all those stand, my lord, my learned competent junior has very effectively, in my submission, my lord, has very effectively dealt with, saying, yes, it is only you are the third one. Come here. Well, only one paragraph in the affidavit in reply. Yes, affidavit in paragraph 4. Paragraph 4. Well, as my learned friend has taken this stand in his affidavit in opposition, in paragraph 3. In paragraph 3, my lord, all this, my lord, the ongoing events, my lord, after events, he has referred to all this. So, my lord, in paragraph 4, I emphatically deny that the present application has become infructuous by virtue, his judgment and order dated 21/1/25 passed by the Honorable Justice Joyce and Gupta. Judgment dated 21/1/25 affirmed by the division bench of Topobrata. But unfortunately, Justice Joyce and Gupta, sitting upon WPA 29578 of 2024, well, this is an order, this is a writ application, well, an offshoot of the original writ application, which is pending. Justice Joyce and Gupta also relied upon this order. So, reliance of an order made without determination, without assignment, gives a sanctity, a question I am asking. And I am placing before your lordships for your lordships' kind consideration. because it has been relied upon, even by the Supreme Court. Does it give a sanctity? Does it give a sanctity? A question, my lord, I am agitating. Then, I say that the instant application being canned for, the applicant called upon the Honorable Court to recall the order dated 2nd January 2024. I further say and submit that the orders made without having determination of the cause by the Honorable Chief Justice in accordance with the prescribed procedure is invalid, void, and of no legal sanctity as determined by numerous judgments of the Honorable Apex Court. My lord, your lordship will throw me the question, yes, where are those numerous judgments? I shall come to. Judgment of this Honorable Court. The Honorable Single Bench as well as the Division Bench relied upon those illegal orders in their respective judgments. It is submitted that reliance upon orders passed without valid and legal determination cannot give any legal sanctity on the ground that the same was relied upon by a single bench or division bench or the apex court in a cause which was not before them for adjudication for any other purpose. For any other purpose. These are all language, my lord. I give my thanks to my learned competent junior that she has picked up the words from the judgment delivered by the apex court for any other purpose. It cannot be relied upon for adjudication. It cannot be relied upon. The instant application is for a decision as to the legality or propriety of the order dated 2nd January 2024 made in Can 1. I believe, my lord, paragraph 4 is sufficient enough, good and sufficient enough, my lord, to reply to the attempted justification of the validity of the order which have come for, my lord, a recalling by this honorable. So this is what it is. My lord, the order I have come for recalling was made on Can 1 of 2023 filed by my lord. Can 1 was a stay application. In appeal number FMA 133. FMA 133 of 2020. What was FMA 134? Limited to the interim order. Made in the contempt application which was disposed of. The stay application. That one, my lord, a stay of the order dated 22nd 11/2023, passed by Justice Aniruddha Rai in CPAN of 1553. Your lordship will find that Can 1, that order of Justice Aniruddha Rai, your lordship will kindly find it. Can 1. Lordship, in my application for recall, that is Can 4, your lordship finds it as Annexure A1 at page 15. As Annexure A1 at page 15.
That we are discussing from 12 onwards, there is a resolution because Bar Association and
For the
Incorporated Law Society is
farewell
going to
to the Honorable the
felicitate
Chief
Chief
Justice.
Justice. Yes, yes.
Yes. Another, yes. Up to 12, yes. We do not want to. Thank you. CPAN 1553. Yes. The CPAN 1553. Your lordship at page 15. Your lordship got it. Your lordship, this is the order dated 22nd 11/2023. And in the stay application in can 1, my learned friend's pair was in can 1, my learned friend, a stay of the order dated 22/11/2023. My lord, subject to your lordship permission, my lord, I have to place the entire order. My lord, and this is a big order. My lord, this starts from that is 7-8 pages order. For tomorrow? No. Tomorrow? 8. Because I have to place the entire order. Thank you, Jeff.
Send second file to his lordship. Please, absolutely.
Your lordship will rise now. But 12 o'clock, my lord, the bar resolution.
Call the next. Is after 3. And
My lordship, I have one submission to make. My case is at item number 7, WBCT 48 of 2022. I am coming from 250 kilometers almost.
you are the petitioner appellant.
I am respondent.
Who is the petitioner?
Both sides are present. If it be possible, it will take not more than 5 to 10 minutes.
Yes.
Seven.
Because if both sides are here, we can proceed. There is no problem.
Thank you.
So you please wait. You please wait. Please wait.
Sir.
Please wait. Call the next.
Item number 5.
आपका है। हम्म,
जी सर 1806 2000 I was posted at Manipur, Chorachandpur. I received a message from IGP Sector Port Shillong that J.K. Misra immediately report to Battalion Headquarters at Srinagar. When your petitioner reached at Srinagar, Commandant M.S. Bariana, my lord, M.S. Bariana called me in office and issued a premature retirement from service to presiding officer, AC, assistant commandant, already signed on that paper. Also, your petitioner signed on that paper and received the premature retirement from service on 31st August 1996. The appeal which was filed by Union of India, this appeal was pending, but they called me, my lord, and they issued the premature retirement from service. My lord, your petitioner challenged the impugned order of Honorable Supreme Court. The Honorable Justice at Supreme Court, S.P. Parocha, and Honorable Justice V.N. Khere passed an order on 3rd November 1997 that writ petition dismissed, but liberty to petitioner to file application of writ in same relief. Yani regarding premature retirement is legal or illegal, court must be decide this matter. So, my lord, your petitioner filed application of writ WP 915 of 99 and also filed a CPN contempt application 495 of 1999. Date fixed, my lord, and my lord, Honorable Justice Asim Kumar Banerjee passed an order not passing they already see the judgment passed by Honorable Supreme Court, but they did not passing the premature retirement. Already he passed an order that strictly department pay the amount which is available of the petitioner. My lord, I draw your kind attention that Ashok Kumar Das Adhikari, Honorable Justice Ashok Kumar Das Adhikari, issued the rule and direct the respondent Secretary, Ministry of Home Affairs, Government of India, Director General, CRPF, CGO Complex, Lodi Road, New Delhi, IGP Sector Port, Shillong, DIGP CRPF, Imphal, and Commandant 27 Battalion, CRPF, personally attend the court of time of the hearing this application. But the respondent, Learned Council, submit AIR, perhaps 1998, passed by Supreme Court, that malaria is an international disease. For this regard, the respondent did not appear. They submit AIR, All India Reporters, passed by Supreme Court. After this, Honorable Justice Dr. Sambhuda Chakravarti and Honorable Justice Jamal Bakshi passed an order and allowed the application, but the department again filed an application in Supreme Court. I reached at Supreme Court, and Jagdish Singh Kehar and Umesh Mishra heard this matter. I engaged senior lawyer at Supreme Court, Parmanand Katara, and so many learned counsel already. I paid the amount, my lord, 50,000 rupees in Supreme Court. But the Honorable Justice Jagdish Singh Kehar and Honorable Justice Umesh Mishra remained this matter in Calcutta High Court for same relief. The Honorable Justice Ashok Kumar Das Adhikari nobody can adhere on behalf of the petitioner. The petition dismissed. I did not again file against the order of Honorable Justice Ashok Kumar Das Adhikari at Supreme Court, because this matter already, my lord, pending, and Kurian Joseph and Honorable Justice Pauline Nediman pass an order that leave granted and petitioner get financial benefit. This order passed by Supreme Court. For this regard, my lord, my contempt application already pending, WPCRC 337 of 2012 in Honorable Court number 16, Tapovarta Chakravarti. My lord, the learned counsel Chanda appeared on behalf of the Government of India. On that period, my lord, I was in person. My lord, I draw your kind attention of this Honorable Court. My lord, already I argument in front of the Honorable Justice at court number 16 that, my lord, this matter already passing by Honorable Court regarding premature. Nobody in Supreme Court or High Court, so many learned counsel, learned judges of this Honorable Court did not question the premature retirement. But Honorable Justice Tapovarta Chakravarti already seen the writ petition fully and passing the premature retirement from service. My lord, your petitioner submit the modification application and already he passed on order that petitioner entitled for all benefits. The premature already crossing till my lord in 1996, 1997, 1998, 1999, 2000, 2001, 2002, 2003, 2004, 2005, and 24th February 2006, your petitioner entitled for all benefits, because this matter already quashing by Honorable Court. And your petitioner also typed that my juniors, my lord, I was appointed as a head constable in 20th August 1969. This is the Constitution of India, and retired from service as a rank of head constable. Head constable retired from service as a head constable. This is the Constitution of India. So, my lord, I draw your kind attention that appeal was dismissed, which was filed by Union of India in 17th March 1998 by Honorable Justice Satyobrat Sinha and Devendu Bhushan Datta. Allowed appeal dismissed, but rule allowed, and already he directed the respondent that petitioner entitled for promotion as a rank of senior grade commandant and paid the areas which are illegally filed by the department, CRP department, misuse the power, my lord. He misused the power and pass an order, my lord, the premature. So, my lord, I am entitled, I am poor person, and I came in this court for justice. My lord, may kindly give me justice and pass an order, your lordship found fit and proper. This is my last submission, my lord.
Yes.
What he has said is all mostly correct.
See, 915 is the order now.
Now in 915, in the pleadings it was stated, but prayer, there was a very vague prayer. Court possibly did not proceed on that. Then appeal was preferred again. Appeal court did not possibly see this actual relief, because he was at the same time he was fighting for claiming two reliefs, although he did not have, because a contempt proceeding was going on regarding his first dismissal. He, in the writ petition against stress, was put on these the past areas. His case at that point was what he is submitting is absolutely correct. But unfortunately, he
was claiming parity with someone
yes,
who he said has been promoted,
yes.
and he was junior to me.
That was given that was given till the date of his premature retirement, and he would have got, had it the premature retirement been set aside, he would have got whenever they had retired.
But the fact remains it was not set aside, and that matter travelled up to the
No, that traveled to division bench.
division
He
bench.
did, against the division bench order, no appeal was preferred.
That is the order passed in 915.
Yes, my lord. 915 was subsequently challenged in
So he got the benefits of which post?
for when they retired, as per his parity was maintained, and when he retired, at that point parity was given to him.
That gentleman with whom he was claiming parity.
They subsequently continued in the job. He was retired. They continued. They got promoted. He is saying that he should get that post which at which they retired. It is the petitioner's claim, my lord.
But the fact remains that he was never, his premature retirement was not
properly pursued, my
No,
lord.
but fact remains it was not interfered with. And holding it as it is, the court said if he is claiming parity with someone who was junior to him, you give that to him.
Yes, yes.
Which has been granted, which they claim that.
Yes, yes, my lord. That was in contempt proceeding granted, because that related to the 1988 order. He had to be given parity. So throughout all these were given on the basis of his actual reinstatement. But subsequently, for some reason, he could not convince the court or something, my lord, because that was the main case at that point of time.
So what is his prayer today?
He wants benefit as if
he is arguing 915 again.
He is arguing that my lord Justice Chakraborty had set aside that is incorrect, my lord. That perception of his is not correct. My lord Justice Chakraborty did not set aside that
Oh,
dismissal.
did you ask him? That's why we requested you to help.
I have, Malad, he has taken it very badly.
Oh.
That
No, we are not trying to discourage him to do anything
Yes, sir.
because we don't expect him to know everything about the procedure and all. But has he been made aware that his only remedy was by challenging the order before the appropriate forum?
No, he did. He realized it after the writ petition was disposed. He in fact filed an application for recalling.
Recalling
He
is
filed an application for recalling, but court still could not. It was possibly not. There was no specific prayer. Firstly, my lord.
so. Therefore, if he tried his, he filed a writ petition.
He again filed an appeal.
He filed a recall. He
Yes.
filed an appeal before the division bench. All these forums he
Yes,
could not
exhausted.
convince for any reason whatsoever, not properly placed,
correct.
whatever may be.
Whatever.
So he still had a remedy.
Before the honorable.
So is he aware of this or not?
I don't think so, my lord. Although he is aware of all the procedure, आप जो सुनिए, आपका जो ये जो रिट पिटिशन 900 कितना था 915 ये जो आपका आप चैलेंज किए ना डिवीजन बेंच में, उसके बाद सुप्रीम कोर्ट गए थे 915 के अगेंस्ट में? नहीं गए. No, he did not.
Kapoor Pradhan Chakraborty already seen the
Yes. Other than that, other stuff.
on and 915 W of 1989 already he crossing. There is no question arise to.
No, वो तो
again,
बाद में.
I mean division. Why I have went there?
No.
Without-
That is afterwards.
This is the decision of honorable single bench. This is the judgment of honorable single bench.
Yes,
Why I have against the why it is Supreme Court?
This is in 2019. इससे पहले तो आपको.
No necessity to that. Oh, court must be my lord.
His remedy
Decide this
was
matter.
actually
What is wrong,
915.
what is right, my lord?
He has challenged. He has set out
This
the.
honorable court will decide this matter, my.
There was an appeal order.
No. Now, my lord is totally. He is claiming something that is not on records.
I obey the direction of honorable Supreme Court.
Lordship,
I
Lordship,
challenge the impugn
Lordship
order of
comes to
honorable
page
Supreme Court
73 of the
and
compilation.
SP Barocha and honorable.
Of the my compilation.
कहाँ लिखा है जज?
Let me-
सुन चुके हैं. दोबारा नहीं कहने का जरूरत. आपने जो बोला है वो सुन चुके. वो पूछ रहे हैं, उनके मन में जो हो रहा है वो पूछ रहे हैं.
Lordship, page 73 of the compilation. That is the order passed in appeal against 915. MAT 915, Lordship.
এটা কোনটা রিকলিংটা না? এই তো দেখেছি, এই তো
এটাই MAT করেছিল।
No, he started pursuing the contempt.
Then it was a contempt.
He went back to the contempt. Yes, Malad. Although that is much later. 2000. This is in 2004. That is in 2019. And my Lord Justice Chakraborty has recorded his submission.
Total submission.
He has recorded and said.
That is.
Yes. He has recorded his submissions and then said. Even after that, an amount was directed to be paid. Yes.
That has been paid. Yes.
1,63,000 something, which they said yes, we are paying him,
Which
and
we
then they
had paid.
Yes.
that was paid to him.
And this was on the basis of that old 88 order.
Old 88 order.
Because the promotion was with. Because that was actually an error of calculation.
Yes.
Yes, my lord.
Yes.
Honorable Justice Kapoor Pradhan Chakraborty, paragraph 9 kindly see that premature return, no honorable justice in Supreme Court or High Court. No judges of this Honorable High Court at Calcutta quashing the premature retirement. Only one judge already seen the WB 915 W of 19 according to direction of Honorable
This-
Supreme Court.
This
They-
is 111 page. The
Yes, they
paragraph 9 is
quashing
111.
the premature retirement from service and department paid 1,63,000. My lord, 3 years already I wait for pay the amount.
So this
The
paragraph,
department did
Paragraph
not
9,
pay
paragraph,
for
paragraph, sir, janna.
Paragraph-
no, paragraph I did
Correct.
not see.
9, paragraph.
Now I'm.
Do you want to say paragraph?
ये paragraph
1,63,000 per department did not pay 3 years. After this, again your petitioner file a contempt application PN 1023 of 2023. On that period, my lord, the Honorable Justice tell me frankly in court that I send you jail if you have got a single paisa from the government of India. Already I went there my account at Chapra and back history of 2019, 2020, 2021 already I have obtained and submitted court. After this, the Honorable Court pass an order that department is responsible. Why not obey the direction of the Honorable Court and the accountant general CRPF New Delhi send me 1 lakh, my lord, 1,73,000 rupees already sent me. After this, the case listed and Honorable Justice Kapoorka Chakravarti, my lord, kindly see. Already I submit the supplementary affidavit in Honorable Court on 12 July. My lord, 12 July already I have submitted the supplementary affidavit. This matter already pending. But in 8th August, my lord, Kapoorka Chakravarti, Honorable Justice Kapoorka Chakravarti dismissed the contempt application. My lord, kindly see this matter already dismissed by Honorable Justice at Kapoorka Chakravarti. Again, your petitioner file an application of copy of the passed by the Honorable Justice Kapoorka Chakravarti. And already I have seen file application certified copy of the judgment. Already I have sent, but the judgment did not receive as yet, my lord. 3 years passed away. The Honorable Justice Kapoorka Chakravarti. So I went there in my neighboring place and take the judgment of Honorable Justice passed by on 13th September 2019 and file an application MAT tender of mandamus appeal in 12 September. This matter already pending, and today just now I am coming. I am a poor person.
so 180, 1806 is pending. 1806 is pending. 1806 MAT is pending.
Yes, MAT now this matter is going to be started.
All right.
This matter already, I filed.
This is 1806.
Chief Justice said, Chief Justice, my lord, assigned this matter on 3rd
All
September
right.
2024. My lord,
We have heard you. We have heard you.
waiting for final.
We have heard you.
May kindly consider this matter as your lordship found fit and.
All right. Very good. Nothing.
So, my lord, he is basically challenges Justice Kapoorka Chakravarti.
Yes, he is challenging the 13 September 19 order. And he's at the same time he is saying that in that judgment the honorable judge has found that he was wrongly prematurely retired. Let us see. Very well. Heard the learned, heard the supplementary.
Take a copy hand. Opposition.
Item number 6.
I appear for the petition.
Could I appear for this thing? General inspector.
Yes.
The private respondent, being an employee in the clerical cadre and a working president of the rival association, the petitioner had been taking a leading role in the demand for dearness allowance for the government employees.
Taking a leading role?
In the demand for dearness allowance for the West Bengal government employees.
Oh.
He is in the MSME department and presently an industrial development officer. The private respondent is the working president of the rival association and in the clerical cadre. He wants me to be pushed off to a distance, which is unprecedented as it appears from the note sheets of the organization. No officer had been previously transferred to a place which is more than 500 kilometers away. From headquarters to a block. Administrative exigency, no doubt I cannot challenge. But 294 is the document, in the writ application, where the state respondents carefully seek to suppress the note sheets. I draw your lordship's kind attention to 294. Your lordships get satisfied from the production of the note sheets, and I won't lose your, I won't waste your lordship's precious time. Let them produce the note sheets. Please come to page 294 once.
Only, my lord, if your lordship don't take me amiss, this 294 was initially where my lord may recall that matter, my lord, your lordship has already remanded back to the, my lord, before the learned tribunal. Because my lord, the affidavit, because only observation was one observation that the decision should be on affidavits.
Please
Affidavit
allow
were not
them
there.
to make their submission. Unless you have a preliminary
Yes,
objection,
yes,
you
yes,
please
ma'am,
allow them to make their submission.
Please come to 294, the penultimate column of that page. I am led by Mr. Bhattacharya.
Yes, yes, please. 294.
Appeal concerning the reply of SPIO regarding query number 17. It is, I'm sorry, query number 5 at the top. Larger public interest does not justify the disclosure and sharing of such information under 81J, and sharing of such information may cause unwarranted invasion of the privacy and confidentiality of a government office. And what was query number 5?
This is by the PIO.
This is by the appellate authority.
Appellate authority.
Let them produce that file. That will conclude the whole issue.
Previously, the deputy director did not want this transfer to be effected, so the committee had to be altered with the induction of the clerical cadre being the working president of the rival position, president in the group, so that he could influence the entire process. Please come to page 153. That's the query.
May I take leave without I have to just second.
Please. 153.
Yes, not. That's query number 5.
153. No more?
Huh.
153.
Please provide copy of note sheet pages that contains processing and decision of posting of industrial development officers arriving to the order of 7th May 2025 of Director, MSME Government of West Bengal.
So the transfer order is 7525.
Hello.
I have read it from 29 July. When notes is dated from 29 July. 29 prayer. 29 July থেকে এই ডেট থেকে চলছে।
So what happened before the tribunal? The issue is finally disposed of.
Yes.
Previously, High Court
In the first round, the Honorable Court was pleased to remand us to the tribunal because during the summer vacation, the tribunal was not functioning with the adequate strength. So with a limited protection, we were
This
remanded.
vacation. After
Yes,
this.
summer vacation.
Yes.
But we went back before the tribunal. The Honorable High Court directed exchange of affidavits before final disposal. Without permitting affidavits to be exchanged, not the tribunal disposed of the application, dismissing my claim. Then not we were before your lordships in the second round. Your lordships directed that since the earlier order of the High Court had directed the tribunal to consider this on affidavits, how could the tribunal reject the claim without a decision without inviting affidavits? So we went back on the second round. The second round, not he has elaborately discussed what the law is about, but without going into the question of malafide factually. The nature of interim order was in the second round when we were before this honorable bench, not to insist upon the transfer. So they stopped my salary, but did not insist on my transfer. From July 2025, I am without salary. Now, not from 29 July 2024, that's the date from which we have sought for production before the information officer as well as before the SPI as well as before the appellate authority, because that was the triggering point when this gentleman was brought in the scene.
When was he brought in the scene according to you?
Not, the committee was reconstituted on 8th of April 2025. And the proposal for transfer was initiated by him on 30th July 2024.
Yes.
Pages 151 and 121, 124 respectively.
151 and?
Now please come to 151 first. This is dated 30th of July 2024.
Yes.
This is a caption of proposal for transfer of industrial development officers.
Yes.
Just after the column in the middle portion, there is a signatory, namely Satyajit Swarnakar, signing on 28th of July or 30th of July 2024.
Yes.
He is the private respondent and the working president of the rival association. I'm not. This is in the pad of the directorate. I'm sorry, the rival association's letterhead. And please see the endorsement just beneath the date. 30th of July 2024, there is a date. Just after the date of 30th July, there is one Shaha.
Yes.
Shaha is written. But he has endorsed, please discuss on 1, 2 and 11. Mr. Shaha was the director. Now 2 is my client, 11 is another gentleman, and 1 is 1, 2 and 11. Now 2 is my client. Similar, the association proposed for transfer of these persons. Now, initially
what is the, we cannot read the letterhead's caption, it's faint.
There is a typed document as well at 152.
Oh, on the next page it is
No,
typed.
next page, it's typed out.
152.
But this is in the official letterhead of the Federation, dated 30th July 2024, addressed to the director of the directorate. Right hand side, Shaha, please discuss on 1 to 11, signed director MSME. 2 is my client. Just beneath the column in the middle portion is the name of the private respondent. We had actually signed. So not we sought for. Now, not please see the constitution at page 124. 122.
What is at 122?
No, 120. Yes, 122. 25th March 2025. In pursuance of the order number so and so dated 8/1/2025 of the Director MSME, Sri Sudipto Shahar, Joint Director Employment MSME, has been entrusted with the works related to transfer and posting of all employees or officers, including new appointment under the Directorate of MSME. But please recollect that endorsement Sri Shaha at page 153. Now, for smooth and effective compliance of the order, a committee being constituted comprising of the following officials. 1, 2, 3, they are all joint directors. Note the sentence just after the column. The committee will look after all the issues above and put the concerned file to the Director MSME for taking decision. The committee will be assisted by Sri Sumit Roy Chaudhuri, Additional Director, and Sri Anit Chakraborty, IDO, and Head Assistant Establishment, Directorate of MSME. Not this Head Assistant Establishment is that Swarnokar, the private respondent. All officers and joint directors level, except for this clerical cadre employee, who is deciding the transfer of superior officers. All have been named. Only this person identified by post.
Yes.
I'm not. This is the first instance where at the block level an ID officer is being posted. 294.
There is any bar to such posting?
There is no bar, but just as a.
No senior officer, 15 years.
Please come to page 294 once. I just show it as an instance.
15 years.
Just to show what is the past practice. Now, if there is a deviation from the past practice, there has to be an exceptional circumstance for that purpose normally.
No. That we have understood what you're trying to say, but we just wanted to know, is there any bar?
There is no
So
bar.
it is not as if he's on a lower assignment. That's not factually
Probably
that.
it is. Probably it is.
Actually,
Because not they have been an officer with an experience of 15 years had always been sent to headquarters of the district, not at the block level.
Yes.
Now, please come to 294.
294.
My lord.
94 the beginning. Second.
Query number 12. Reply to query number 12.
Explain why such a situation. What is the situation?
Yes. Page 290.
Page 294.
Yes.
It is the third column from the top. Appeal concerning the reply of SPIO regarding query number 12. Usually, no senior IDO with more than 15 years of experience is transferred from the directorate headquarters to a BDO office unless constrained by a situation as it has evolved concerning the districts of Alipurduar and Darjeeling, where there is not a single IDO for total 6 blocks of Alipurduar and 5 blocks of Darjeeling district except Siliguri subdivision. Because of such situation, recently 3 senior IDOs having more than 15 years of experience have been transferred to the BDO offices at a distance of more than 200 kilometers from the directorate headquarters. 3 IDOs having experience of more than 15 years have been transferred beyond 200 kilometers, and 1 IDO having experience of more than 15 years have been transferred to BDO office at a distance of more than 500 kilometers from the directorate headquarters.
25 years. Should I vote on one time, my client? One time.
I'm not, in fact, not for your lordship's convenience, not instead of rummaging through the entire brief, not we have the manner in which not I have indicated, we have prepared a flow chart with the documents not enclosed there too. Oh. Date was not 30th July 2024 is that proposal and recommendation by the rival working president. So we have sought for production of file from 29th July. 8th of January 2025, Mr. Shah, Joint Director, was assigned duties to consider transfer. That's in running page 5 to 11. Please come to page 5. At page 6. Now the second name on that page 6. Matter Sri Sudip Shah. Matters relating to establishment of the directorate along with transfer and posting of all employees or officers and new appointment. So Mr. Shah was the sole person responsible for effecting transfer. Now, that is on 8th of January 2025. 25th March 2025, this committee is constituted, which was page 122, being running page 12 herein. Please see, running page 12, in pursuance of the order number so and so, dated 8 January 2025 of the Director MSME, Sri Sudipto Shah, Joint Director, has been entrusted with works related to transfer and posting of all employees or officers, including new appointment under Directorate. Now, for smooth and effective compliance of the order, a committee is being constituted comprising of the following officials, the 3 Joint Directors. The committee will look after the issues above and put the concerned file to the Director MSME for taking the decision. The committee will be assisted by Sri Sumit Rai Chaudhary, Sri Amit Chakraborty, IDO, and Head Assistant Establishment Directorate of MSME. That is the gentleman concerned. Then what reallocation of this job to Shoikat Datto at page 20. Just because not the Joint Director was opposing to these 3 exceptions, so not only this committee had to be inducted, but not he had to be denuded of his power, and somebody else had to be brought in to comply with the recommendation or proposal of the committee within 5 days' time. Your Lordship has seen the constitution of the committee is 25th of March 2025. Please see the top sheet, the list of dates.
Yes.
Not on 3rd of April 2025, another order is passed. That is at page 13. In supersession of the order dated 8/1/2025 and all earlier order related to the distribution of jobs among the additional director of MSME, joint directors and WBSO and officers, deputy director of MSME have been reallocated, keeping in view the better coordination of works of other directorates as hereunder with immediate effect, and will continue until further order for smooth running. Please turn over to page 14. That is Sudipto Shah, the second entry on that page. Sri Sudipto Shah, Joint Director. Please see the second entry, II. The committee constituted video order dated 25th March 2025 will look after the transfer and posting of all employees or officers and new appointment. So although the order says that it was to assist the Joint Director, but actually this is the committee which is considering the posting of all employees. Then what? 8th April. Again within 5 days time he had to be, a fresh order had to be issued. Please see page 20. Now the power is given to Sri Shoikat Datto at page 24. The last entry on that page 24, please see the first entry. Matters relating to establishment of this directorate along with transfer and posting of all employees, officers of the new appointment. And 7th May 2025 is the transfer order. So the undue haste or the uncanny promptitude with which the particular department was acting, and that too in quick succession, leaves no manner of doubt that this effect was sought to be achieved in a particular manner.
Yes.
Not the careful manner in which these note sheets have been sought to be suppressed or not withheld on the ground, but a state is supposed to come up with an affidavit disclosing all facts, not when questioned, before a court of law at least.
Which note sheet they are suppressing?
Not
According-
29 July 2024 till the transfer order was effected.
24.
29 July 2024.
So
30th
1 year
July,
prior to your transfer.
yes. 30th July 2024 was the proposal by the association.
The foundation of transfer.
But that transfer has taken effect about 14 months thereafter.
No. It has taken effect from 7th of May
24 or 25.
25.
So therefore, we are saying 14 months gap in between the recommendation by the federation
Yes.
and the transfer.
No, this
It's
is
not-
no. That's 14 months. July 2024.
Correct.
It's 9 months.
9 months. 9 months.
Now, I'm not. Your Lordship has been pleased to find on the recommendation that earlier director had given his reservation or dissent.
No, he
The
has
note.
said discuss.
1, 2, and 3 is to be discussed.
Yes.
So, but for the purpose of discussion, the same gentleman who had proposed the transfer, a clerical employee being the rival president to association's working president, is brought in. In quick succession of 5 and 5 days, that is 10 days, the committee and the authorities changed.
So therefore, it is more after his coming into the committee or assisting the committee. You are not relying very much on that recommendation. You are just trying to show that that is the basis.
And the
Ultimately-
constitution of committee, because not although that order says that this committee is to assist the persons, but the order of constitution of the committee says that it is to take the decision.
No. Where is that? Where is that?
Yes,
To
please
take
come to the constitution of committee at page 12.
That committee, which is comprising of, the committee is actually only 3 members.
Right. Now, please see the second subparagraph after that column.
So they are not committee. They are assisting the
If not,
committee.
I just show the subsequent orders by which not the committee's role has been defined.
Let's see.
The committee shall be assisted by so and so. Your Lordship has been pleased to find.
Yes.
Now, please come to page 13.
Yes. Not 13, 14.
At 14.
Yes. Again, the committee.
The committee constituted will look after the transfer and posting of all employees, officers, and new appointment.
Yes.
Now, not comes the reallocation of jobs at page 21. At 24.
This document is dated 8/4/25.
8/4/25. It says in supersession of the order of 3rd April 2025 and earlier order related to the distribution of jobs amongst the additional director of MSME, joint directors and so officers. Deputy director of MSME have been reallocated, keeping in view the better coordination of works of other directorate as hereunder with immediate effect and will continue until further orders for smooth running of day-to-day office administration. Please turn over to 24. Shri Shoikat Datta, Joint Director of MSME, Durgapur Zone. He is from Durgapur Zone. Matters relating to establishment of this directorate along with transfer and posting of all employees of officers of new appointment. And not before that, all along I have been saying, please keep the committee and its assistants clean. Please remove the rival associations president from this committee and for all purpose from this entire exercise.
No, this also, where does it say that matters relating to establishment along with transfer and posting is by this, what is his name, Mr. Saikat Datta,
Yes.
not by the,
He is the person who is to take the final call.
Hmm.
That's why we called for the note sheets. Where is the discussion? Who has taken part? Was he really a person to assist clerically, or was he taking the decision? Was he a part of the decision-making process, to which I had always
did you
objected?
file a reply before the tribunal?
Yes. Yes.
Not
I'm
disclosing
very-
this.
I'm very much obliged to your lordship. But first of all, but the main harping by my learned friend. But page below 151. Sir, thank you, sir. It is thorough. 151. 151. But they have actually relied upon. The 151, that is the malafide intention of the authority concerned. But according to them, bullshit. But only, Lord, your lordship kindly consider in the affidavit before the learned tribunal, we have categorically stated this is fabricated one. This is fabricated one. And I will show, I'll show from the reply of the affidavit, they have not denied, they have not actually dealt with. Number one.
No,
Yes.
before the
2
tribunal,
to 5. Yes.
before the tribunal, have they made a specific assertion that it is at the on the recommendation of this person, whoever he is, if they have made it, if they have made that assertion and they have said that this will be available from the documents, have you dispelled that doubt
Yes,
before the tribunal?
fabricated.
So let us show your
Yes,
reply
yes.
before the tribunal.
Page below 2 to 5. 2 to 5. 2 to 5. Huh? They have stated in their petition below 117, and our reply, Lord, your lordship kindly turn to Lord able to come to page 2 to 5.
2 to 5.
2 to 5.
Number 4.
Paragraph 4.
According to
My lord has got it 2 to 5.
Just a minute.
Paragraph 4 of our Lord the reply.
EG 117. It has to do with the passenger. Right.
My lord has got it 2 to 5.
Yes, we have it.
According to middle portion. According to me, my lord has got it according to me. Middle portion.
7.
Yes.
According to me, the documents in the instant application at page 83, 87, 90, 91 and 117. 117 is the relevant. 117 out of the aforesaid documents, page 87 being annexure P7, page 90 and 91 being annexure P9 were not received by the office of the director MSME. The documents were totally false and fabricated for the purpose of obtaining an order from this honorable tribunal.
And they to you.
And they have dealt with Lord
At their rejoinder.
222 for 76.
This is their rejoinder.
Paragraph 5. 276. I deny and 1 to 7, the said reply, I deny and dispute each and every allegations made in the said reply 7 except what are matters of record, what may be borne out as true construction thereof. I repeat and reiterate the statements made in original application 322 of 25, miscellaneous application 82 so and so. I deny and dispute the applicant has filed the application in gross abuse of process of law. There is no specific denial and there is no, my lord, there no specific harping that yes, we have the document. And my lord, Lordship kindly consider this. 11 years, my lord, he is in the headquarters. And there it is, my lord, the journal transfer in the administration 7th May 2024, 26 candidates. Out of 26, my lord, 25 have already joined. And he, my lord, he only the person, my lord, only showing that I am the post holder of portfolio holder or post holder of an organization. That's why I should not be transferred. কত পাতায়? 129. And Lord, if your lordship kindly see page 129, the transfer order. This is a chain transfer.
That we have seen. There
Yes,
is a,
IDO, my lord,
that order has 26
my lord,
names.
120. And Kalchini, there is no IDO. Only this IDO has been transferred there. But Election Commission has already wrote a letter.
6 vacant post? No.
My lord, if your lordship kindly see 6 vacant.
See what?
6 vacant post IDO Kalchini. No,
Don't give us
my
something
lord,
which is not on the record.
my
I
lord.
don't want to see something.
But this is records, my lord.
This is part of the record.
But this is this is actually related with this.
So many things are related. What they want to see is also related.
My lord. But
Yes.
this is my submission. 11 my lord, years he is in headquarters. Number 1. Number 2 is a condition of service. My lord, your lordship knows, but I should not trouble to your lordship about condition of service is a transfer. And my lord, the document he has relied upon page 151.
Appointment letter লেখা ছিল।
জানি এটা বলতে বলছি বলে
Yes.
And Lord, the page 89, and in the appointment letter, Lord, it has been categorically stated, his service in the post will be governed by the appropriate rules in force and in liable to be transferred in anywhere in West Bengal and when required.
That is not disputing. That is not disputing.
No, that's why, Lord, I'm showing to your lordship for
He
this.
is trying to make out a case of.
And my lord, not only that, if your lordship, I can show to your lordships the orders, the division bench order. My lord, his wife made an application before the RTI authority for asking the documents, and the before expiry of the statutory period, my lord, he filed a writ petition, and the petitioner was the second writ petitioner.
Yes.
Only to stall this transfer order. Thereafter, my lord, an order was passed. We preferred an appeal. The appeal court, presided over by the Honorable Justice Devangshu Basak, my lord, not entertained. No, sorry, you go and for your appeal is pending, statutory appeal. But there should be no relief.
No,
Thereafter,
the appellate authority has given his reply.
thereafter, appellate authority has given. My lord, and my lord, if your lordship has already seen.
So why?
Sudipto Saha is
Yes.
not there. Thereafter, this was changed on 8th of April 2025 in supersession of the order video number 3rd April and earlier order related to the distribution of jobs change among the additional.
Where are you reading? Which page?
Lord, this is other page কত নম্বরে আছে? The Soikot Dotto, just now my land friend has shown to your lordship. Soikot Dotto has, this Saha is not at all in the picture. And thereafter, the transfer order was passed on 7th May 2025. Therefore, my respectful submission is this, my lord, what is the reason behind the petitioner to, my lord, stay at the headquarters and not to, my lord, it's when, my lord, out of 25 persons have joined. What prevented him to join there?
উনি তো জেনারেল সেক্রেটারি অফ ওয়েলফেয়ার অ্যাসোসিয়েশন, সেটা তো 2024 বা 25 হয়নি, অনেক দিন আগে থেকে। আমি যদি বেনিফিট ইন্টেনশন থাকতাম আমি তখনই পাঠিয়ে দিতাম কোথাও।
And he is the portfolio holder, and since long back, we have not transferred him. But here, my lord, in the interest of the administration, the entire chain transfer has been.
Where is that APIO's response that you were showing us?
294 RTI.
It's not in this compilation that you have put.
No, page 294. Lord, can you take the towel at page 294?
Compilation page 47.
Lord, I have,
47. In my short compilation.
Lord, I have opened my case saying that if that document is produced, not everything will solve. I am not against transfer. I know that transfer is my part of.
That frame,
That
no,
document is-
tribunal application is scannable.
So which document do you want them to show?
And this is that, see the document, query number 5 at page 153.
This is in response to question number 7.
Question of 5,
Question number 5 at which page?
page 153. And question.
No, is it in this compilation?
Yes, no, compilation, I
There is no
cannot.
prayer as such before the tribunal. The appellate authority already given by the order of the Honorable Division.
My narrator will kindly hold his patience. 153, my lord, the question was
155.
Please provide the copy of the question number.
question number 5. Please provide copy of the note sheet pages that contains processing and decision of posting at industrial development officers arriving to the order number so and so. That was a specific query. But this query, they say, in a larger public interest, it cannot.
That is an issue which is for the authorities under the Right to Information Act.
But that is different. That is completely different, my lord. But the question is, when authority refuses to disclose the file relating to order of transfer, that smells a rat. Why the authority withhold the file? Let it produce before the court.
That was the
But my-
prayer before the Honorable Division.
My, the poet,
If I am not wrong.
no, before the honorable division bench, this was issue about the non-action of the
No, no.
RTI authorities,
No.
not about this transfer. Let him appreciate. it.
No.
No, but essentially today also you are saying the same thing.
No, what I'm saying that this being the foundation of the order of transfer, but my allegation is without of
Page 166.
malafide and malice in law. Now, that malice in law can be proved only from the decision taken by the authorities, whether it was done bona fide or not. And you are withholding that document.
No, but have you in the proceeding before the tribunal, have you at any place stated that this note sheet will contain?
Yes, yes.
Where is, let us see from the OA.
And they come to the tribunal's meeting. The tribunal will not, after the lordship was pleased to remand it, asking them to decide on affidavits.
Yes, now we remember.
The
Yes.
tribunal unfortunately did not at all go into the question of this allegation.
So where is your assertion before the
Yes,
tribunal?
let kindly come to the OA. Wait a minute. 34. Page 34. 35. Yes, 35.
34 of this compilation.
No, the repetition of the. 35. We have the paragraph H, I, J, all without the allegations of instances of his involvement in a particular organization. Which
Page 34 is
page start, Lordship may
35.
start from page 35.
35.
I've given the instances without at page 38.
The order of appellate authority.
Hmm.
Separate
38, 13, these are the instances given.
Page 48 has stated.
Then kindly turn to me that page 48.
No, this you are saying that you have been taking up some issues of the association.
That is the background. Now kindly come to page 48. Your subparagraph may be M. Your applicant states that subsequent to the filing of the instant repetition, the applicant has come across a document as the general secretary of the so and so.
Subsequent to the order of
For
the authority,
proposal of transfer of industrial
private
development
to accept the
officer
order
and
of the
astonishing
authority before the appropriate
the
court.
applicant's
Fact
name
10
with
to
the
the
decision number
private
2.
is accepted.
And the
Order
documents
in
contain the
state,
signature of so
which the private
the
exponent may
applicant
action the order of
complaint
July
of
20.
harshness in transfer. Then Lord, this was taken up by this court.
They are able to see page 59.
Then Lord, kindly come to me, Lord.
top at page 51, subparagraph Q,
এখনই দেখালো তো এটা।
on the basis of political influence and therefore appropriate privy initiative against
So where is this document of 30th July 24?
Look, that is that page.
Yes, now I have shown to your
Page
lordship.
40, 48. No, I have page 48. Your document is at your home. Document is that
Page 151,
51,
short compilation, page 3.
150.
page 3 of the short compilation.
Page 3.
Yes. But this is the document which they say, I will show the denial. Kindly see the signature of few individuals. Then, yes, put up in file.
Director এটা লিখছে 1 to Shaha.
Kindly has seen that. Below.
We have come to that document.
Yes, kindly come to below. Page 153 at the right hand side top. That's the director is writing, Shaha, please discuss on 1 to 11.
Yes, that he has shown us.
Yes, yes, paste it. And this is signed by three other individuals and the rest put up in file. This is signed by the director. And then pilot will kindly
Wait, sir, the specific reading আছে page 273. Your applicant states the entire note
Number-
date from 29 July 2020.
kindly turn to page 273, specific reading about these documents.
Government note sheets. আমাকে অ্যাপ্লিকেশন করতে বলেছিল হাইকোর্ট, তারপরে গিয়ে আমি করেছি।
Without 273, without the Roman 20. Applicant states that the entire note sheets filed from 29 July 2024 relating to detailed processing and arriving at the decision of transfer is produced and a copy of the same is handed over to the petitioner. But it's not easy, Millard, for a particular Millard individual to get all the documents of these states. Therefore, this pleading was made and see how they have dealt with this. The affidavit, Millard, which was placed by my other friend, whose affidavit is this?
110, 110, 110. See the book,
Page 210, paragraph
Kindly see it will be affidavit by
Page.
page 210. And we come to Millard at page 211, paragraph Roman 2. With reference to the statement within so state respondents are denied and disputed the same. 7 accept that what are matters on record. Therefore, this is no denial. It is a fact that the director MSME by an order dated 25th of March 25, appearing at page 88 of the Instant Way, had constituted 3-man committee who were entrusted with the work related to transfer and posting all employees, including new appointment under the director. This is the admission. But much before the issuance of the implement order of transfer, so and so, the industrial development, including the application, said directed in suppression of earlier orders, so and so. Reallocated the matters relating to establishment, director, so and so, the admission. But I am not troubling my life with the rest part of it. Interesting that above mentioned at page 213, Roman 4. Specifically stated, but what is the director?
Yes.
MSCB neither received any such letter dated so and so of Rajya Sarkari Karmachari Federation so and so, nor acted upon the same in any manner whatsoever at the time of issuance of the transfer. But this has to be, my lord, corroborated by the voting seal file. Then applicants has to make street proof of that. How could the applicant make street proof? What is your recording in the file? And these are all verified as true to knowledge, nothing else. And with another interesting affidavit by the individual who against whom I have specific content. Affidavit so kindly now turn to page 225. This is the affidavit of the individual. It discloses much more interesting features.
225 is whose affidavit?
The individual against whom I complain that you have
Regarding whom you are alleging malafide.
driver. He acts and files an affidavit. Kindly with that, see the admission. It is paragraph 3. It is stated that the instant way filed by the applicant nothing but out of personal liability against me. Now, what could be the personal liability of the director or officer to a clerk? He admits that he has some liability. Then can we come to next page 225? It's very interesting. It is a fact. Page 225. This is the affidavit and reading the paragraph 4 of the gentleman. I say that the director MSME by an order dated so and so has contributed 3 main committee relating to transfer and posting all employees, including appointment, where my name being head assistant directorate so and so appeared, allowing others just to assist the said committee. But prior to issuance of the instant order of transfer so of 26 industrial officers into the applicant hearing, since in suppression of earlier orders had dated so reallocated the matters relating to establishment of director along with the transfer of posting all employees and new appointments so and so. Then it is a fact that I am the working president of the Paschim Bengal Rajya Sarkari Karmachari Federation. The applicant hearing who claiming himself as general manager, secretary of rival association, West Bengal Industrial Development Officers Association. That the association is of 1 officers who are a member and he is part of the clerical staff. According to me, the documents to the instant application, according to me, the documents in the instant application at page 83, 87, 90, 91, 17, out of the aforesaid documents, page 87 being annexure F, page 90, 91 being annexure, so were not received by the office of the directorate. How could he know?
That he had placed.
Therefore, this is again without a tacit admission. Therefore, I say that most humbly, Lordship need not be troubled. That I am a transferable person, I have to go and transfer, but it must be without free from bias and malafide. Let that file be produced. If your Lordship will not judicial satisfies, I am out. But if your Lordship finds that he is involved with this there, otherwise without larger public interest. The similar point came up before this court that I had led up in a judgment of House of Lords in here said that except the state security, nothing can be withheld.
Therefore, we are saying when that issue has been taken up by you on the under the Right to Information Act, then that issue is to be raised in an appropriate proceeding. That cannot be. That's a collateral issue. How we can go into that in this proceeding?
And there was no
And
prayer.
in the interest of respect, I ask that you must disclose all the documents. That is the fundamental duty of the administration. In administration, while that was undaunted to disclose it, I had to go to RTI.
No, whether we are just trying to see the law. We don't know what is going on. In such a transfer matter, whether the court should go and look into all these aspects, the files which have been processed leading to the issuance of transfer. Is it required?
Yes, when the allegations are specific and the specific allegations are in fact admitted, then the court judicial conscience, I again say, if your lordship after looking at the file says, no, there's nothing, I'm out.
No,
I'm-
that we appreciate what you are saying.
When an officer will not find that his transfer is being dictated and motivated by persons who are not otherwise authorized, that demeans my status. And what the other RTI discloses that never before a person of this rank was transferred beyond 200 kilometers. I have transferred 700 kilometers. But still then I say that if the law permits, yes, but not the question comes not the application of law. How the authorities will not have applied it. Why for the first time a person of this stature is being knocked out to not 700 kilometers away? This should be different.
You have any precedents to support this? The court exercising jurisdiction to look into the documents of transfer, the decision.
So Lordship gives him time, I should not come up with this.
No, my lord, before that, my lord,
Tomorrow,
before that,
tomorrow,
no, before that, my lord, with due respect,
Tomorrow, 10:30, I have a decision.
day after?
After I'll out. Tomorrow at 2?
Yes, why not?
but before that, my lord,
Please let
no,
them
with due
complete.
respect to my learned senior
We
friend,
will
lord.
hear,
Nah, that minute, both
we
of them.
will hear both of you.
No, yes, but the point, my lord, your lordship has specifically asked. No.
No,
Specifically,
see, don't,
I will should do two
What-
documents. It
whatever-
has been dealt with by the coordinate bench.
whatever we are observing, everything is prima facie. We are just trying to see what the issue is. Don't try to read anything to it.
No, not
our
he, but my learned friend is harping on that. Yeah, why the
So let
document
us
has not been
see,
produced.
let us see the legal
Kind-
position.
Kindly see the 166. But
Of course.
it has been submitted before the honorable division bench.
For the
Let them come prepared with the file, if court necessary, we look into it. Or then further time for production. Can continue.
let them do what they want.
It will take time.
We'll see. If they take time, we'll see. They have heard all the submissions. So they know what to do.
I'll follow mine.
Yes. Which matter? Oh, yes, we said it is not required to be listed. Yes. ले लो उसमें फाइल में रखवा दो मृदुल को भेज दो हाँ
Item number 7.
My lord, this is a
This process was for what? Appointment of?
this selection dispute. Lordship, kindly come to page 241 in volume 2 of the paper book.
No, we are just want a background.
My lord, the question is, my lord, there was a promotional exercise
Internal.
initiated under the limited departmental vacancy, 70% from seniority and 30% from the merit come seniority.
So it is not a direct recruitment post.
No. So this is my learned friend is in the limited departmental examination. He participated way back in 2015.
LDE for which post? That is what
For the post of assistant financial advisor.
From which post?
From group B post.
No, this has
Group C post. Sorry, Group C post to Group B post. That is
Senior section officer.
senior section officer to assistant financial advisor.
All right. So this limited departmental examination was conducted
In
2015.
15.
He participated.
He participated.
It reached the
My lord.
declaration. Was the result declared?
No.
Not
Result
declared.
not. My lord, initial date of written examination was on 21st of January 2016.
Yes.
And that was revised to 8th February 2016.
Yes.
That date,
Yes.
it will. My lord, this examination was consisting of 2 papers, paper 1 and paper 2. So, my lord, paper 1 examination was cancelled.
So both exam was conducted,
Both exams were
but
conducted.
one was cancelled.
One was cancelled.
One was cancelled by which communication? There must be some notice.
Yes, yes.
What
That
is-
is at page 247 of the paper book.
So that is the impugned order before the tribunal.
That was the impugned order initially before the tribunal. Subsequently, my lord, the
Yes.
my lord, page 247 of the paper book,
Yes.
whereby, my lord, the paper 1 examination was cancelled.
Yes.
So, my lord, the re-examination date was and time was fixed in terms of notice in 2016. That is at page 248.
So the examination of paper 1.
Re-examination of paper 1. So, my lord, the applicant being aggrieved, my lord, preferred an application before the tribunal. And the tribunal's direction was to make a representation and to consider it by an exhaustive
That
order.
OA was numbered as?
That way was numbered as 1825 of 2016.
for quashing of cancellation order of paper 1. But that has been disposed of by directing the authority to
represent in this regard.
To issue a speaking order.
And then a speaking
My lord.
order was issued.
My lord, subsequently what happened, my lord, the re-examination was held for paper 1.
Conducted.
And re-examination was held, my lord, on 16/11/2016.
And what is the
My lord,
what is the date of order passed by the tribunal?
My lord,
in 1825 of 2016.
that is at page 252, 50 to 252.
7916. No.
Yes.
Not 2117.
Yes. Order dated 2/1/17.
So in the meantime, the re-exam was conducted.
Re-examination was conducted on 6/11/2016.
16/11/2016.
16/11/2016. I'm sorry.
Did he participate in that or?
Yes, yes. My lord, subsequently, my lord, he made various representations for publication of the result and this, that. My lord, I'm skipping that. My lord, in paragraph J, K, and LM, Lord, you kindly have a look to the page 8, 9 of the paper book 1. My lord, we have explained as to why this cancellation was done.
No, so this is the facts of the
Fact.
case.
Now, my lord, what
He
happened?
participated in the process, one paper cancelled for re-examination, notice issued, assailed before the tribunal. Tribunal said represent. In the meantime, he had already sat for the re-examination. What happened in the re-examination?
My lord, after re-examination conducted, my lord, the authority cancelled both the papers, paper 1 and paper 2.
And when that was done?
That was done on 9/2/2018, page 278.
So that is the subject matter of
That
the
is the
present
subject matter of the OA application
way
before the
the
tribunal. My lord, the tribunal's order is, Lordship kindly find at page 73 to 89 of volume 1. The order under challenge. Page 88 at the bottom.
What reason did you assign before the tribunal for
Lord,
taking
the
this?
vigilance objection that
Where
was
is that?
Lord, I have stated in paragraph J, K, L and name of the application. Lord, page 8, Lord, you kindly come.
When you cancel a selection process in this manner, there is no requirement of giving a notice.
That is the requirement, but it was not.
RP 192, what is the number?
No. 1 minute, my lord, lordship, kindly see.
Somewhere we have seen that. One case. This is our railways.
Yes, TLW, Chittaranjan Locomotive Works.
There is an RBE we have seen in one case.
Yes.
Which says that notice has to be given.
No, in ordinary cases, notice is to be given, but the normal that any action taken.
And in extraordinary circumstance,
Yes,
not given.
My lord, I cannot say that before your lordship, but it has not been done rightly or wrongly.
So, what is the ground on which?
My lord, subsequently, what happened, my lord? Lordship, kindly. The order passed by the tribunal and the application was disposed of on 21st January 2022. In the meantime, my lord, in 2021, there is another notification was issued for limited departmental examination, 30%. That is at page 186.
(136).
186. For filling up the post of assistant financial advisor. And lordship, I should clarify that this vacancy period is for 2 years. Initially, in 2015, the vacancy year was 2015-2016, 14-2016. And then 18 and 20, both the vacancy years are clubbed together, and finally in 21,
So
my lord.
Tribunal has directed to conclude the recruitment process.
Yes.
Which recruitment process?
That's why, my lord, I am submitting that in 2021, there was another notification, and my learned brother expressed willingness to participate in the said interview for the said post. And my lord, subsequently, he was selected and he has joined the post. So, my lord, during this period, my lord, the re-examination part, the authority did not consider, because since he has joined the post, and in the meantime, my lord, during this course, my lord, 4 or 5 persons have retired from the post.
So this
section officer.
His joining is on which date?
He has joined, lordship.
Just give us 2 details. One is the second recruitment process dated.
Second recruitment process, my lord, was initiated on 8/11/21.
Yes.
And
my lordship,
my learned brother expressed willingness to participate in the selection process by letter dated 3rd January 2022. Lordship will find it from page 196.
Yes. And he must successful.
Yes.
So he joined as assistant financial advisor.
Financial advisor.
When? 25th of January 2022.
Yes.
Actually, interview was conducted on the date the CAT's judgment was pronounced.
And he was 25th of January 2022, he joined the post, my lord. That is at page 194, volume 2. And he wrote a letter to take charge of the post, and that was given to him. My lord, the seniority is counted from the date of passing examination. So this part,
which
lordship,
means which date?
That means from the date he qualified, that is, this seniority is to be counted from 25th of January 2022. So, my lord, this part, lordship,
so then the writ petition, what remains in the writ petition?
That is the thing. Writ petition, my lord, there are certain lapses I have no hesitation to accept, because in the midway the selection process was cancelled. But
No, we are saying, what do you want? What relief you can get now?
No, I have come since they have not challenged that order. My lord, I have come before your lordship, my lord, or the CLW has come before your lordship, that at this stage, a re-examination is not possible because he is already in employment and in the same said post. So the direction passed by the tribunal is that the original order either is to be given effect or
No. Has the
alternatively
cancellation be quashed by the tribunal?
Yes, my lord, that is the 73 lordship, kindly see.
No, where has the tribunal quashed the earlier, the cancellation?
No.
Page number 88.
Huh?
Page number 88.
88, right, the lordship. No, the tribunal's observation is that having noted no report of large-scale malpractice or corruption, nepotism, we are of the considered opinion that the respondent should be directed to complete the selection process.
Therefore, we are asking you, has the cancellation been quashed?
No,
Not
that has
quashed.
been, but the even re-examination of paper 1 may be conducted. But during this period, my lord, up to 2022, it is
so therefore we are asking you for the railway, what remains in the petition?
Cancellation that is true, that is implied.
For the present, what remains in the writ petition for the railway? It is practically it is infructuous now.
So, my lord, if your lordship finds the order, my lord, that it has already been cancelled.
Where?
On 9th of 9th.
No, cancelled 9th February 2018.
But there is no specific direction that has not been. The washing order is not there, but the direction has been issued to hold
complete the process,
even if necessary to hold re-examination.
Even by holding re-examination.
By this time, my lord, the process has been, the second process has been completed.
Therefore, we are saying this is now infructuous. What remains? What will remain?
I leave it to your lordship, my lord, because
he has not challenged the order.
No. We challenge that it is practically not possible at this stage to take re-examination, or because the persons who participated in the earlier process are not in employment, and re-examination is not possible.
My lordships,
he has not challenged this order. We have challenged this order. So if your lordship feels that
actually the previous examination was for vacancy period up to 2016, and the examination in which I have been selected was up to 2020.
That we have understood, sir. That we have understood. What you are now, you will be thinking that if this order is implemented, I will get it from 16. This is what you are thinking.
My lordship.
But that cancellation has not been set aside by the tribunal. Then
But
how the tribunal can direct for completing the process?
But they have challenged on the ground that there was a.
You have not challenged. That's the point.
No, sir. I am not challenged.
You could have challenged that why tribunal has not quashed the order. Without quashing, how a new process can be conducted? You tell us. Unless that cancellation is set aside by the tribunal, how they can proceed? That cancellation will stay and they will proceed also. How it can be?
But railways have still kept 2 posts vacant.
May have
this selection.
May have. They are impending contempt. They have kept it.
Yes, definitely.
Then you have not challenged this order. This order is as it is. We don't know how such an order has been passed.
My lordship, there was a
direction
to complete the selection process.
The direction to hold a selection process or complete a selection process could have been a consequential direction after quashing the cancellation. Once the cancellation has not been quashed, how it can be? How it can be implemented?
But there was a direction by Honorable Cat.
196.
The selection process.
196. How many times you will say that? He has already said it.
Yes, sir.
We have said it. Now you are saying it. That does not improve anything.
And this seniority he is claiming,
where is the notification by which the 2016 process was initiated.
2016 process was initiated, my lord. That is at page 241. এই সম্ভব অসম্ভব ওই যে এটাতে বলা আছে না যে সিনিয়রিটিটা ফ্রম দি ডেট অফ পাসিং এক্সামিনেশন আমি দেখলাম হ্যাঁ সেইটা এখানে ছিল কিন্তু সেটা এটা এখানে আমি পাচ্ছি না দাঁড়ান আপনি
This is conducted under which rule? You have the rule.
that is selection process was conducted under lordship kindly come to page master circular that is at lordship kindly come to page 62 of the paper book. That is the rules regulating seniority of railway servants as well as the না সেটা ঠিক আছে কিন্তু
It is 262. Master
This
circular
is
is at
for seniority purpose.
Master circular is at 262, sir.
oh acha,
262.
260 oh this is the seniority position and 262 is the master circular. Yes, thank you. Yes, 263
And the method has been categorically stated at 264, 1.1.
yes, this was the master circular.
Para 2.201 of Indian Railway Establishment Manual.
Yes. Yes, my lordship.
And in page 66, my lord, lordship will kindly find that the seniority position has been explained in the seniority for promotion as section officer to inspectors of stores accounts such and such. Seniority for promotion to the rank of section officer accounts or inspector of station or stores account should count entirely according to the date of passing the examination. This is for the non-gazetted people and gazetted is at page 69.
So he is covered by which one?
He is covered by page 69, second gazetted. That rule is followed from the date of passing examination.
Where is that? Page 69.
Page 69 is for the gazetted.
My lordship, 334 by 1.
He is covered by which one? At page 66 or 69?
Page 70. Page 70, 334 by 1.
No, this is promotion to group B.
Yes.
Then how this will apply? This is for group B to junior scale of group A.
Yes, sir.
But this is not junior school scale of group A.
But at that time, panels are considered on the basis of the vacancy year for which
assistant financial advisor is which group?
From group C to group B.
B. Then why you are reading group A? How this will apply? Just what does 334 say? Read it.
Yes, sir, I have seen, sir.
Then how that will apply? That will not apply to you. That is for From group B to junior scale of group A.
Group A.
You are not going to junior scale of group A.
No.
So section B gazetted. So which will apply, 66 or 69? He is already a section officer, senior section officer, prior to the promotion process. So 317 will not apply. So probably 319 will apply. At page 67, because this is a non-selection post. It is filled up only by promotion.
Seniority on promotion to no selection. That is for non-gazetted.
Hmm?
But the selection process, your seniority for promotion as section officer, that is non-gazetted.
Hmm?
That has been followed in page 66. C17 has been followed, rightly or wrongly, because my lord, the seniority is to be counted from the date of qualifying or for promotion.
You please read 319 once. You also see what
Sir,
31.
I have seen. The last line matters, sir. Actually, what I wanted to tell that seniority is maintained on all India basis for promotion from next days. So
the one who qualifies later will be junior. This is what 319 says.
yes, obviously.
One who has qualified earlier will prevail. He will be senior, and the one who qualifies later will be junior. Now you have already got your seniority. So what can be done?
Sir, for
Even if the tribunal's direction is carried through and you qualify, do you want to lose the seniority that you have got by virtue of this recruitment?
Appointed from this date.
Because then that will be subsequent to this.
Sir,
The result will come after this. Even if the tribunal's direction is carried, if he is forced that yes, you have to carry through the direction, then you will have to participate again in paper 1. You may not qualify. Even if you do, what will you gain? You want to lose this seniority, because this will follow from the date of result, from the date of passing.
Sir, but panel seniority is maintained, sir.
Where? Panel? Where is the panel?
I mean, assessment of vacancy period. So that was for the post.
We are not going to look at what is in your head. We are going to look at what is here. What does this say? What does it say which helps you? Please read out that sentence. Which helps you. If the tribunal's direction is carried out, then you will lose the seniority which you have already got. Because that will be a subsequent result. The railway servant would see what it says.
Once promoted, it turn after being found suitable against which is non-portfolio should be considered as senior in that grade. Yes. It's
Can you show us any provision which says the date of notification of vacancy will be the date on basis of which your seniority is to be counted? We are unable to find. We are looking at the provisions, whether 318, 319, 316, they all say from the date of
qualifying the exam.
result. The day when the result is issued, that will be the date on which you will come to occupy the higher post. And obviously, prior to that, you will not get any senior. So now, even if that direction is carried out, that will be a futile
Will be
exercise. for
futile
you.
exercise. Yes.
Promotion to non-selection post shall be on the basis of seniority and suitability. The trade test has been done, but the exception is where considers to necessary to point certain other. Then only
Yes,
if they do it, it can be only on ad hoc capacity in short-term vacancy, not exceeding 2 months.
Not
This will,
required.
however, not give the servant any advantage, not otherwise due to, not confer on him. A railway servant once promoted in his turn after being found suitable against a vacancy which is non-fortuitous should be considered as senior in that grade. Servant once promoted in his turn, now you have once been promoted, found suitable against a vacancy which is non-fortuitous. This is non-fortuitous because you have been examined, you have been your assessment has been done. Should be considered as senior in that grade to all others who are subsequently promoted.
Yes.
Now you want to go for a promotion exercise subsequently. What will you get? You will not get anything.
And so 319B, an employee who qualifies in an earlier test and gets promoted in a non-fortuitous vacancy but reverts to the lower grade before a subsequent test is held will rank senior to all others who qualify in the subsequent.
Correct. So you have never qualified in an earlier test. Now the test will be subsequent.
Sir, because the results were not declared, sir.
But this test will be subsequent. It does not say qualified under an earlier notification. The notification has not been made the basis. The date of vacancy is not relevant.
My
It
lordship,
says qualifies in earlier test. So qualifying is the relevant date.
my lordship, tests have already been done. Examination was conducted, already conducted.
Mr.
Both the papers.
Mr. The tribunal has said conduct an examination of paper 1 and you are saying already conducted.
They have given an option, my lord.
So that means it is nothing. That means it is nothing. You have not challenged the order. That's why we said you could have challenged, but you have not challenged. Nothing can be done. Yes, take down. Heard, learned advocate.